Okay. Well, good morning, everyone, and thank you for joining us today. I am thrilled to be joined yet again by John Gilbert from Sandberg Phoenix. Him and I teamed up last fall in November. It seems like just a few days ago, but time has gone so quickly to do this event live in Edwardsville. So, if any of you were able to attend that event, I hope you have rejoined today because you've been thinking about some of those topics. Maybe you have some questions after the fact you left that you wanted to ask, or maybe you were thinking about. So, if you were there, I hope you enjoyed this presentation again today. We're going to focus on key employment law updates that are impacting companies as we are, getting started here in 2026. Some of those topics are going to include federal guidelines on overtime calculations, the evolving landscape surrounding DEI initiatives, upcoming tax proposals on tax on tips, overtime wages, some non-compete updates, and then we'll get into some things in Illinois that is started and is kind of going along with the national trend that we are seeing. Now, there obviously is a Q&A box, a chat. If you have questions about these topics as we are going through them, please send your questions in. Let us know. We want to talk about them kind of in real time. I can be looking at those questions as they come in and make sure to bring them attention to John. And of course, I'll have my questions as well because once we get talking, I start thinking, oh, and if I'm thinking it, hopefully you're thinking it. So we can dive in. John, anything before we get started?
No, Summer, just want to welcome everybody and thank them for taking the time to join us today. As Summer indicated, we presented a similar program back in November live, and at least as far as we're concerned, it was a big success. And so I just want to thank everybody. And then I'm required by legal ethics and my law firm to tell everybody that what I talk about today and what Summer and I talk about today is not to be considered legal advice, but is informational. And we urge you, if you have questions or still have questions, especially with regard to compliance, that you consult your legal counsel. And in a shameless plug, I would be more than happy to be your legal counsel in regard to these matters. But I think that's it. Thank you, Summer.
All right. And I'm sure someone will ask, is this being recorded? Will this be sent out? Yes, we are recording this. It will be delivered via email, I believe later today. That will be going out. So, all right. Now that we have all of the formalities out of the way, John, I guess it's time to dive in, right?
I'm ready.
Okay. So let's start with overtime calculations. And John, when you and I touched base yesterday, this had a little bit of an update from what we visited in the fall. So the Department of Labor put some new guidance out just last week on the 5th. So can you kind of walk us through what's going on with the overtime calculations and really what employers need to know as far as interpreting those opinions?
Thank you. Yeah, one of the big issues that we have seen recently, and when I say recently over the last couple of years, but especially in the last year, and I've seen it in my practice, I've talked to other professionals who've seen it in their practices, and it's both for private and public employers, and it's the issue of bonuses, and especially the impact bonuses have on the calculation of the regular rate for the purpose of determining overtime payments. So, as all of you know, for non-exempt employees under the Fair Labor Standards Act, overtime for any hours worked over 40 in a week has to be paid at time and a half the regular rate, the employee's regular base rate. One of the issues that has emerged, and this has always been an issue, but it seems to be more acute lately, is what about bonuses. If employees get bonuses throughout the work year, at the end of the year, whenever they get them, including employees who have bonuses pursuant to collective bargaining agreements, what's the impact of the bonus on the determination of the regular rate that is the base for the calculation of time and a half for overtime? And the Department of Labor has for a long time, the Wage and Hour Division has for a long time opined that if bonuses are not truly discretionary, meaning that they're completely in the control of the employer, they're not predictable, they're not promised, they don't measure, or they're unrelated to performance often, then they have to be counted in determining the employee's regular rate for overtime calculation. But it's been ambiguous for quite a while. And we finally, we had some guidance from the Department of Labor, Wage and Hour Division about this and how you differentiate between discretionary and non-discretionary bonuses. On January 5th, the Department of Labor, Wage and Hour Division issued a series of opinions, one of which was particularly apropos to this subject. And the opinion letter, and I recommend that, even though it's not a regulation, I would recommend that employers who are faced with having to calculate overtime go to the Wage and Hour Division website, take a look at these opinions. But the important one was that overtime, that the bonuses, if they measure performance, if they are rewards for performance, or, and this was one that really got our attention, even if they're provided for in a collective bargaining, if they are in any way non-discretionary, in other words, the employee is entitled to them, then they have to be figured into the calculation for overtime. So you divide the bonus by 2080, and that's the add-on to the employee's hourly rate in figuring overtime. So the impact, of course, is obvious that even if you have a collective bargaining agreement, let's say, that says that a bonus is paid at the end of the year, but it's not to be included in the calculation for overtime, that those may not be enforceable. We don't know. I have a test case right now where I'm going to find out under Illinois law. So this is a big impact, and that's why I urge everybody to take a look at those opinions, because this will have tremendous implications for employers who have to pay overtime to non-exempt employees.
All right, John. So, what are some of the biggest compliance risks whenever they're looking at what falls into overtime and what doesn't? And if they fail to adjust, kind of what does that look like for those companies?
Yeah, well, it can be very expensive, Summer, because under the Fair Labor Standards Act, an employee can, especially if a violation of the act is willful, can look back to 3 years of back pay, 2 years if it's not willful. And I think because of the ambiguity over this issue, it may be a little more difficult for an employee to prove willfulness, but there's at least an exposure of 2 years of back pay under the Fair Labor Standards Act. So I would expect to see some class actions filed across the country based upon this, especially because the opinion letter says that even if you have a collective bargaining agreement, that doesn't help you from the bonus if it's not truly discretionary. So two things I think employers need to pay attention to. One, take a look at those bonuses and maybe try to figure out how to address the compliance issue. But the other side of it too is take a look at those opinion letters and the current FLSA regulations and err on the side of caution in determining whether or not a bonus is discretionary or non-discretionary, because it appears that a lot of bonus programs that we once thought were non-discretionary are now, I mean, once we thought were discretionary, are now going to be labeled as non-discretionary, which is not, honestly, this is not something we expected from the Trump wage and hour division, but apparently they're pretty serious about this.
So my mind keeps going to, I need to talk to our payroll team and
Yes.
figure out how do HR teams kind of keep this organized in, looking at what's discretionary and what's not. And through the year, how do you even separate those as an employer to keep track of some of those things?
Yeah, I mean, that's a challenge. And it's a challenge to payroll teams, it's a challenge to auditors. And the best advice I can give at this point is for employers to familiarize themselves with the regulations and the opinion letters that define what's discretionary and what's non-discretionary, because it's a narrower category now for discretionary bonuses, and they almost have to be arbitrary to be discretionary now. So it behooves anybody who's dealing with payroll and auditing to get familiar with these regulations and opinion letters, especially.
Yeah, definitely. Okay, let's stay in the realm of payroll and taxes and all of that fun stuff. We know last July, the one big, beautiful bill brought us some different tax proposals that we have been hearing about. So let's hit on, we've got no tax on tips, no tax on overtime, and then also what's going on with the Social Security tax deduction as well. So, we kind of have a few of those different tax things to look at.
That's a good question. And this is something everybody's interested in, especially because unlike a lot of tax bills, this one takes effect for tax year 2025. And so the IRS is revising tax forms, putting out information to the public about these three issues especially. And, tax returns can begin to be filed on January 26th. So this is very, very timely. So let's start with no tax on tips. This was a promise that President Trump ran on and has made a reality through the One Big Beautiful Bill, which I guess we should now call the One Big Beautiful Act. But and the way they did it was kind of interesting. It's in the form of tax deductions, which is a kind of an interesting approach. And so for the tax on tipped income, it's an deduction up to $25,000 for single taxpayers, $50,000 for joint filers of overtime. So if an employee is in a profession tips, talking about tips, not overtime, that's next. If an employee is in a profession with typically tipped income, they can deduct up to $25,000 from their tax returns. And it's an above the line deduction, as we call it. So it really comes right off income. And this is a pretty good deal. Now, there are income limits that apply. So you have to be sensitive. It dissolves at particular income limits. I don't have it in front of me, but I want to say it's $75,000 for single filer and $150,000 for joint filers. Then you can't take advantage of it. But for those who are under the income limit, this is going to be a tremendous boost for them and a nice refund coming back. And as you've indicated in your question, it takes effect for the year 2025, which is unusual for tax legislation to apply to so quickly. So this is going to be a big boost, I think, for for middle class employees who are typically tipped employees. The tax on overtime is not so generous. I was a little surprised personally that the tax on overtime is capped at $12,500 or $25,000 for joint filers. And again, it's a deduction, above the line deduction, so it's valuable. But for those who make a lot of money on overtime, and a lot of people do in crafts, in law enforcement, public safety, a lot of employees make a lot of money on overtime. And frankly, I think this deduction is kind of stingy, but it's there and can be taken advantage of. It's $12,500 for individuals, $25,000 for joint filers, assuming they have overtime. And again, it has income limits. So if you make a certain amount of money, you're not going to be able to take advantage of it. But again, it's a good start in terms of what the administration is trying to achieve with this, which is putting more money in the pockets of middle class taxpayers. And again, it'll be reflected in the forms that the IRS is preparing and that your tax preparers will be able to advise you about if you use one. So these will have an impact on employers because, and I haven't gotten a lot of feedback from employers yet, but you may have at HireLevel on how this is going to be accounted for by payroll, because it's a challenge since it's a deduction. I'm not really sure, and I'm not a payroll expert. I'm not really sure how what you're seeing from a PEO perspective on how this is going to be handled, if at all, through payroll.
Yeah, so I know that our team is working very hard right now on W-2s and getting all of that information together for our clients. You know, we've got the deadlines to get those W-2s out by. And when it's W-2 season, John, I like to focus on the HR of things. I like to leave
I don't blame you.
I like to leave it to the experts so that they can jump in on that. But from what I'm taking that you're saying, with this being a tax deduction, it's kind of held at the individual level, right? And not as much for the employer. I'm sure on their W-2, it's going to maybe differentiate, how much of your earnings came from overtime and what can you claim there when you go to file your taxes. But as far as that category and what you get on that form, that's kind of where the employer is like, that's what I can do. Now it's up to you to file your taxes and make sure you do it correctly, is what I'm gathering.
Yeah, and I think you're right about that, what's going to fall on employers is being able to segregate regular income from overtime and also what's tipped income and what's minimum wage. So I think you're right. I think that's going to be the burden because then it's up to the employee to implement the deductions. So
right.
I think that's a good observation.
So if your check stubs weren't correct or your record keeping back in July of 25, now you might have a headache to deal with because your employees won't be too happy.
Yeah, that's a good point because, up until July 4th of last year, we didn't know what this was going to look like. Now, on the Social Security taxes, they made a lot to do about no tax on Social Security. And again, the way that's been implemented under the One Big Beautiful Bill is, again, through a tax deduction. Again, not the most generous, in my opinion, but it's a tax deduction of $6,000 and $12,000 for joint filers. $6,000, and again, it's an above-the-line deduction, who are 65 years of age or older as of December 31st, 2025. It also has a phase out at income of $75,000 a year. So this is going to be a big boost to those folks who are in the income levels that are below 75,000 or 150 for joint filers. And it's a $6,000 deduction for the individual. So it's helpful, no question about it. I don't know that it's going to have that huge of an impact. We'll have to wait and see, but that's one employers really don't have to worry about. That's one that will be solely in the hands of the taxpayer. But, again, it's an attempt to put more money in the hands of taxpayers to boost the economy, and we'll see if that works. But again, I don't think it has any implication for employers, really.
I think, John, as you're saying these things, right, as HR professionals, we should just be educating our employees and letting them know these things are there. We don't really have a hand in them. So much that came out with the big, beautiful bill, employees, I think, thought fell on the employer. And so maybe just following up with your employees, like, hey, remember when you're filing your taxes, these things are out there. Make sure whoever you're working with keeps it top of mind as well, so that you do get to receive those benefits. So they don't get angry after the fact and ask why. Why did we tax their overtime
Yeah,
when it
exactly.
wasn't supposed to be there? Prevent that conversation from happening.
No, I think that's really good advice because, as you've said, I don't think much of the obligations here fall on employers, but it's a great opportunity for employers and especially HR departments and HR professionals to educate employees about what the benefits are under the One Big Beautiful Bill. Great.
Of course. All right. I don't see any questions coming in on these topics, so I guess oh, hold on. I was under chat, not Q&A. Let's see what we've got here. All right. Lynn is asking for clarification. Is the deduction for overtime the amount of overtime up to $12,500? If you make only $5,000 in overtime, is $5,000 all you can deduct?
Good question, and the answer is yes. Yeah, the deduction is up to 12,500. So but again, you got to watch the income limits because if the employee's making too much money, he or she is not going to be able to take advantage of the deduction. But we'll see when the IRS releases the forms. We'll see what its position is. But yes, the answer to the question is yes. If they only make 5,000 in overtime, then that's going to be deductible.
All right. Let's go ahead and make a shift into DEI. All right. So there's some increased legal scrutiny around employer-led diversity initiatives. What are the biggest legal risks employers should be aware of right now when they are maybe evaluating their DEI programs?
Yeah, that's a good question. I've gotten a lot of questions about that, especially from employers who have wanted to continue their DEI initiatives. And there's a lot of misinformation out there, which is not uncommon when we have regulations on politically and socially sensitive issues. But here's the bottom line on the DEI approach from the federal government right now. And that is this: what the executive order and the information coming out from various agencies like the Office of Civil Rights and also EEOC, for example, is pretty much this: that DEI initiatives can continue, and what the federal government is going to be focusing on right now is the preference aspect. What current position of the federal government right now is that DEI initiatives are fine so long as they do not result in preferences for any racial categories. So it's not as though a lot of people say we got a war going on against DEI. Maybe that's true in some circles, but as far as regulatory activity, including President Trump's executive order, the focus is on not giving preferences based on race. And so I have clients who are still implementing DEI programs, but where they're being careful in order to not run afoul of the regulators on the federal level is to make sure that these initiatives do not result in a preferential hiring, promotion, whatever the employment action is, based upon race. And so I think that, most employers will be able to continue their diversity initiatives with that one caveat that they have to avoid showing preference to based on race or some of the other protected categories, but primarily race. So I don't discourage employers from continuing DEI initiatives. We just have to stay away from the legal exposure that's at risk if they result in preference.
So, okay, as you're working with these companies they're still continuing with their DEI programs, how are they kind of balancing the preference aspect of it? And like, how have they changed their approach to make sure that they're not going to face that exposure?
Yeah, that's a great question. What I have seen is that there's more emphasis on recruitment, retention, and on inclusiveness in the selection process. And so that when they're hiring, they make sure to cast a wide net for candidates who are qualified, and the emphasis is placed on expanding the pool of employees who are potential employees during the selection process, as opposed to, well, quotas have never really been legal, but a lot of companies used to use them. And under the old affirmative action plans, we had goals and timetables and that sort of stuff. I'm not so sure that that's going to withstand scrutiny anymore, but certainly the inclusiveness in the recruitment selection process is where I am seeing companies put their efforts.
All right. So that continues.
And I'm sorry to interrupt, but also,
No, go
I
ahead.
think I said this, but retention of candidates has become a big emphasis too, making sure we retain employees who are diverse, which helps too. So, and I've seen a lot of emphasis on that, especially in professional, like law firms and other types of professional companies.
So basically, you're saying companies taking the team that they already have and figuring out how they can provide them continuous training or upskilling to continue to grow and hopefully stay with the company rather than having to go out and recruit new employees to fill that spot.
Exactly. Right.
Interesting. Well, it'll be interesting to see how the DEI initiatives continue to grow and expand and different changes ahead in the future.
Yes. And honestly,
adapt.
I'm not seeing a lot of enforcement activity from EEOC in terms of judicial activity. The regulations and the guidance is out there, but I haven't seen in my practice or really in the sources I have to keep an eye on this very much enforcement activity other than perhaps in higher education.
Right. Well, let's go on to the non-competes and updates on the non-compete. So the FTC recently dropped its appeal on the non-compete injunction, returning enforcement to a state-by-state standard. That sounds fun.
Yes, right.
So let's kind of talk a little bit about the non-compete landscape today. And
well, as you know, and as most people know who follow this, the FTC and the Biden administration developed a regulation that outlawed non-compete provisions in the employment context, period. And, and that was attacked in the courts on a number of bases, but the FTC, the court had enjoined enforcement of it, and the FTC was appealing that injunction against the new rule. And when the Trump administration came in, they dropped the appeal because the Trump administration was not in favor of the regulation that outlawed all non-compete agreements. And so the result of that is now it's back to a state-by-state determination. So we have 50 approaches now to non-compete agreements, and it is so the takeaway is, if you're going to use them, make sure you know what your state or any state in which you do business has to say about non-competes. Illinois is somewhat strict. Courts don't favor them. We also have a statute that prohibits them for employees who make less than $75,000 a year. And the courts don't like them, so the legal standards are pretty tight. Other states, I want to say, and I don't quote me on this, but I think about 5 states have outlawed them completely. And I eventually think Illinois is going to get there. But we have now a patchwork of different regulations on non-competes. Some states are more liberal, some states are more conservative. As a management attorney, you may find this shocking, but I don't like non-competes in the employment context. And there is overall judicial hostility to them. So it really requires a pretty high burden of proof of the interest that the employer is trying to protect by keeping somebody from working for somebody else. Illinois, of course, requires now through judicial decision and arguably through statutory regulation that non-competes and employment agreements have to be supported by separate consideration other than continued employment and other than except maybe at hire. So it's almost, they're almost more trouble than they're worth. But there are occasions where, you know, they might be appropriate. But the big problem now is there's 50 different standards across the country, and employers. My advice to employers is think hard before you require one, especially for positions that are pretty fungible. You know, there are situations, I think, in which employers should consider them key employees, maybe one. But given the other options employers have, trade secret protection, one approach to non-competes has been to go to forfeitures of benefits if somebody leaves, as opposed to a non-compete agreement. Non-solicitation agreements are still upheld uniformly. So non-confidentiality agreements are upheld uniformly. So I think that one of the approaches to the patchwork quilt of non-compete regulation across the country is to look for alternatives. And so but we're going to see how that settles when the dust settles, how those things are going to be. But this is especially tricky, as you know, for employers who do business in more than one state.
I know, John. I sit and think about employers that have gone to a remote work environment more so than everybody located in one area. Or even in a place like in the St. Louis area, where maybe some employees work in an office in St. Louis and some are across the bridge in Illinois. Right. You just have different standards state by state. And when so many of our employees are sitting in maybe 10 different states nationwide, how do you determine who gets a non-compete and who doesn't, and who just gets, like a non-solicitation, or right. What onboarding package do you send with which type of agreement there? Right. I think it becomes, like you said, almost more burdensome than actually having one. So we do have a question from Trisha. You were talking about alternatives. She said their company uses liquidated damage language instead of a non-compete. 500,000 liquidated damage. Thoughts on using that instead?
It's definitely an alternative. Now, depending upon what state an employer is in, some courts are hostile to liquidated damages provisions. And this is old law that goes back, to English common law, really, that if liquidated damages provisions are viewed as a punishment or a penalty, sometimes the courts won't enforce them. So you need to be in tune with your state law with regard to liquidated damages. But in the right kind of situation, that might be a useful alternative to a non-compete. But I would definitely check the law of the state you're in to make sure that you have a good grasp on the dividing line between liquidated damages and a penalty clause, so that you don't end up with your hands empty when you go to enforce it. I saw that my good friend Sherry Rode had a comment. Let's see, it's either in chat or the Q&A. I'm not sure.
I think it's in the chat because I'm in the Q&A.
Okay.
Did you find it, John?
No.
Oh, it says states may put limits on solicitation. Like in Illinois, the employee has to earn at least 45,000.
Thank you, Sherry. Yeah. So, this is so highly dependent on state law that you really have to get some good legal guidance if you're going to try to use these. And I caution employers all the time to make sure it's worth the fight if you're going to get a fight. And I see a trend away from non-competes, but toward these other types of alternative ways of trying to keep employees from competing or staying with you, which has also been an issue about regulation, but we may come to that later.
So, John, I think in conclusion here for non-competes is if you truly think you need one, it better well be worth it.
Yes, and get good legal advice.
Yes, good
and
legal
even then,
advice.
That's no guarantee, but at least it puts you in a better position.
All right. So we're going to hop into some Illinois employment law and some different changes there as we transition into our next topic. John, I'm going to jump a little bit ahead on you because I feel like this is the perfect opportunity to go into severance agreements and really just see what new changes or restrictions employers should be aware of and understand when issuing the severance agreements in Illinois.
Well, this is a biggie for us in Illinois, and it is reflective of national trends. In my practice, I often call Illinois the California of the Midwest when it comes to how the General Assembly seems to have a penchant for manipulating every session laws that govern employers. And one of them took effect January 1st, which is an amendment to a statute we have called the Illinois Workplace Transparency Act. And this act was already in place and had restrictions regarding employment agreements. But on August 15th, the new law took effect, amending the Workplace Transparency Act. So now the act restricts what employment agreements, especially severance agreements, can provide for in order to allow employees, even as a result of an employment or severance agreement, they cannot restrict an employee's ability to report violations of not only discrimination and harassment laws, which was already there, but laws and rules related to other issues like collective bargaining and wages and hours. So employment agreements, including severance agreements, may not restrict an employee's ability to engage in concerted activity which is the right to bargain collectively, participate in labor organizations, and discuss collectively work-related issues like wages and benefits. Now, this has been true on the federal level for quite some time under the National Labor Relations Act. I get, I am somewhat surprised by this, but I do get questions frequently from employers, private employers especially, about, they got employees discussing their pay with each other, and the employer frowns on that, but you really, under federal labor law, and now essentially state law, you can't do anything about that. Those protected activities have legal protection, of course. Also, on the new laundry list of things that you cannot have in an employment agreement, including severance agreements, are any terms shortening applicable statutes of limitations for the time periods to file claims. Not that I saw a lot of that in my practice, but it's definitely prohibited now under Illinois law. Also, and this is an interesting one, in Illinois, an employment agreement or a termination agreement cannot apply terms to that agreement of non-Illinois law. So you can't have in these agreements that New York law will govern or Missouri law will govern, but it is now prohibited to have terms applying non-Illinois law to Illinois employee claims, which is pretty interesting. And likewise, we have often in these agreements what are called forum selection clauses, where the agreement will specify where any claims must be brought. And now it's unlawful to have terms requiring that a venue outside of Illinois adjudicates an Illinois employee's claims. So this is particularly troublesome, or not troublesome, but it's particularly apropos to national employers who oftentimes, like I've seen agreements come through where a company will say, a big company that's maybe headquartered in New York will have a provision that says New York law applies. Or if the employee sues, they have to sue in the Eastern District of New York or something, which is, even I would say that's unfair. So now under Illinois law, you can't do that anymore. If it's in Illinois, if there's Illinois employees with Illinois claims, they cannot be adjudicated outside of Illinois by virtue of these agreements. Now, what can we put in? Well, you can still have certain confidentiality agreements. However, the employer has to be able to establish that these were negotiated in good faith with the employee. And so this is pretty important. And if you have a confidentiality agreement, which we still like to do often, it has to be supported by consideration money that, or some other benefit that is separate and apart from any consideration provided for the separation agreement. So if I have a separation agreement and I'm going to provide an employee health care coverage, let's say for a month, in exchange for their release of claims, if I want a confidentiality agreement, I'm going to have to pony up more money to get that confidentiality agreement. And of course, it again has to be negotiated in good faith. So we have to be much more careful in drafting these agreements to make sure we comply with the changes in the statute. So I would suggest to employers and their counsel that they look at the amendments to the Workplace Transparency Act, which again took effect January 1st, and make sure that they understand and implement these restrictions.
Well, John, you kind of, I had my question ready to go and you expanded on it, on how this really just kind of, it will impact employers outside of Illinois, because it does require, when they have employees in Illinois, to follow these guidelines.
So
Really,
that's a big impact.
that definitely is. Once again, back to remote workforce, work from home, people within the state, and the employer may not know. They may not
Right.
understand that.
And as you know, Summer, we have a lot of employers in Illinois, especially in the Chicago area, of course, but even in the St. Louis area, that are national, and they're going to have to be very mindful of these restrictions.
Of course. All right. Some of these next Illinois changes impact new families, mothers especially. So we have the Neonatal Intensive Care Leave Act. So that's something that has gone into play. So which employers are covered and how does this leave interact with FMLA or other state leave entitlements?
Good question. This takes effect June 1st, so it's not in effect yet. The Family Neonatal Intensive Care Leave Act, or what some people are calling NICLA. I'm not a huge fan of these, but in Illinois, employers with more than 15 employees are covered, and you really can't quarrel with the intent behind the act, but it provides that employees with more than 15 employees have to provide for unpaid leave while a child of an employee is a patient in a NICU, neonatal intensive care unit. Employers with 16 to 50 employees must provide up to 10 days of unpaid leave under the statute, and employers in excess of 50 employees must provide up to 20 days of leave. And a child under the statute is what you would think: biological, adopted, foster, stepchild, including the legal wards, or a child of someone who stands in loco parentis, which means in general substitute parent. Again, this leave and your question about how it interfaces with FMLA leave is a good one, Summer, because this is in addition to leave provided under the FMLA. Now, the way the statute works is in the event this occurs, employees have to first exhaust their FMLA leave. Then they can use this leave if it applies. It can also be taken on intermittent basis, just like FMLA leave. And what's an interesting twist under the statute is employers can't require employees to use any accrued PTO prior to using it. So if you have time on the books, you don't have to use it. When you use this leave, that's up to the employee. And of course, just like FMLA, the statute provides that if benefits have to continue during the neonatal intensive care leave, and employees have to be returned to their former position or substantially equivalent one, like under the FMLA. And there's some verification requirements under the statute, but and non-retaliation provisions like we see in all of these statutes. But this one takes effect June 1st, so employers need to be aware.
So, John, does the employee have to be eligible for FMLA to use this?
No, they do not, and that's a very good question. But they do not have to be eligible for FMLA leave to use this. This is strictly based upon the number of employees an employer has, and if the child has to be in a NICU, and the definition of the child has to be met. But no, they don't have to be eligible for FMLA leave.
So is there any time frame between hire and say this instance occurs that an employee has to be with the company? So say, a father started and then the child goes into the NICU, 2 months later, are they eligible then to use this leave and be protected?
I didn't see anything in the act to the contrary.
Okay.
So I would say yes.
All right. Well, sticking with the terms of family, let's look at the Nursing Mothers in the Workplace Act. So there's some updated accommodation requirements, including space, time, documentation, and how employers should handle potential undue hardship concerns when it comes to nursing mothers. Can we get into that a little bit?
Sure. This is a statute that we've had for a while, and it applies to employers with at least one employee. So there is no higher standard for the statute to apply. And the under the current statute, well, now it's amended. This took effect January 1st, but the statute already provided that employers are required to provide a reasonable break time for employees to breastfeed or express for a period up to 1 year after the child's birth. And during that time, the employee has to be relieved of all duty. Under the statute prior to the amendment, the break time could coincide with any break times already provided. Well, now, under the new statute, and again, effective 1st of January, the statute requires that those breaks are paid at the employee's regular rate of pay unless paying for those breaks would create an undue hardship. And an undue hardship, and we're not unfamiliar with that term because it's the ADA. We've got lots of experience with undue hardship under the ADA. But in the statute, which incorporates the Illinois Human Rights Act definition of undue hardship, and has to be prohibitively expensive or disruptive. And there's a number of factors measured against that we don't have time to go into. But what's important to understand is this is now paid and for the break time. And under the statute now as amended, employers may not require employees to use paid leave for these breaks. And so my recommendation is for all employees to review their policies now to make sure they're in compliance with this act, especially because now the leave that is protected under the act has to be paid.
Does the act happen to say like how many break periods are allowed? Is there any restrictions on that an employer can say, one every so many hours, or does it give those specifics for an employer?
The statute uses the term reasonable. So, and I think what that tells me is that unless the demands for a break to breastfeed or to express are extremely excessive, the employer is not going to be able to be too restrictive. I have to say, I have yet to have an employer ask about compliance with this act or anybody abusing it. So my guess is, at least in my practice, it seems to be working out okay, because it is not something that is all that frequent. But employers need to be aware of the requirements, again, especially now that that's paid leave.
Of course, I think, and it's something you have time to prepare for. If you know this is coming, it shouldn't come as a shock, and making sure they do have that space provided that is secure, that is private, and not going to be accessed by others. Okay, let's shift into the Military Leave Act. So what key compliance requirements or common mistakes should employers avoid regarding the reinstatement and benefits when it comes to the Military Leave Act?
Yeah, what they did, we already had a statute for military leave. It was called the Family Military Leave Act. It's now been renamed to the Military Leave Act, for what that's worth. And the change, which took effect January 1st, essentially, let's see, where's my note on this? Oh, here we go. Sorry. I got a note on this and I can't seem to locate. But what it did was it expands leave to cover all employers, again, with 51 or more employees, to provide 8 hours of leave, again, paid leave per month, not to exceed 40 hours in a year, to employees who participate in funeral honors details, which is, a nice recognition of veterans who work for employers with 50 or more, or 51 or more employees, I should say, who on occasion are called out to be honor guard participants for veterans' funerals. So Illinois now allows 8 hours of paid leave per month, again, not to exceed 40 per year, for employees to participate in these funeral honor details. Now, the employee has to demonstrate that he or she is trained to participate in funeral honor details, and they have to be a retired or active member of the armed forces, which includes a National Guard. This is, again, a statute of which employers need to be aware because this is paid leave. And again, I don't know of any employers I've ever run across that have denied employees to do this, but it's now memorialized under the Military Leave Act here in Illinois.
Now, John, I think you're right. I don't know that an employer would really, come back and say, sorry, that's too bad, we can't do that. But I really do think it's great that they have this. My mind goes to record keeping, of course, that if somebody is planning to use this leave, just making sure you have your system in place that it's going to track it correctly. You don't want to pull it from their other paid leave balance and kind of have a little bit of a mess there. Just being able to show that within your system that you're tracking it correctly.
I mean, it's the practical takeaway for all of these is that it creates, good or bad, it creates additional burdens on employers of which they need to be aware and get good advice about.
And sometimes it's instances that don't happen very often. So you may know about it. We may talk about it today, and 10 months down the road, it comes up and you're like, man, I know John and Summer talked about that and I was supposed to be prepared for it.
Right. Well, we're always here, right?
Always. So one last topic. I know we are getting close on time, but John, that's the benefit of us doing this virtual, right? We can use the time.
Right.
So the last one that we're going to hit on is the Illinois Human Rights Act with AI.
Yes.
So
this
AI, we can't get out of this without talking about AI, can we?
No, AI is here to stay and hopefully isn't running all of our lives anytime soon. Seems like it's getting close. But the importance of AI with regard to employment right now is that, again, effective the 1st of January of this year, the Illinois Human Rights Act has been amended to prohibit employers from using AI to in any way discriminate in employment. And this was primarily focuses on the selection process. It's kind of the concept of adverse impact that we have all been familiar with for years under Title VII of the 1964 Civil Rights Act and other statutes, is where they're focused. The concern of the General Assembly was that AI might have built into its algorithms and programs and whatever else drives AI biases from its creators or just general societal biases. And so Illinois employers cannot use AI that has a discriminatory effect on employees. So the immediate concern here is to make sure that our AI programs, to the extent we use them in the selection process or for any employment decision making, doesn't have this effect. Now, the other issue is that under this bill, employers are required to notify employees and applicants when using AI during recruitment, hiring, promotion, renewal of contracts, selection for, any aspect of employment. Now, what we're waiting for is the Illinois Department of Human Rights to publish a rule on how these disclosures are to be made and what the requirements are. So that's also coming down the pike for employers that use AI. And they need to be aware of not just the statutory requirements, but also the disclosure requirements to their employees.
Well, that one is going to be interesting to watch. It unfolds and how employers are responding to it and really how they're using it in their recruitment process and the tools that are out there, right? It's very interesting to see how that's going to play out.
Yeah, I'm anxious to see not only on the regulatory side, but also on the employer side as to how they're going to create these tools, what features they're going to have, and then how they're going to make sure that they don't have discriminatory effects. Right now, I'm glad I'm not a computer programmer.
Well, I think about all of the recruitment that we do internally, obviously, and how our tools have continued to update with different AI features. But, a good recruiter knows at the end of the day, you have to go in and look at what AI has provided you because sometimes the best candidates will get skipped.
I'm sure that's true.
Keep adding that human touch on there. Okay, well, John, I think this covers all of the topics that we had laid out for today. I'm not seeing any other questions coming in, but open to them if anybody has something that comes up. We'll give you a couple of minutes. Will we get a certificate for attending? There will not be a certificate, but we will send out an email from HireLevel that will have the recording. And if you're looking for like SHRM certification codes or anything for your continuing education, we'll send that out in the email. So you will get that later today from our marketing team, and they'll be sending those out. Any other questions? We covered a lot of topics here. I'm sure John and I will be hitting on this again. Maybe June, July tends to be when we do a quick refresh on mid-year, how things have come along, what new updates Illinois has brought us. So if there is anything that comes to mind, you would love us to hit on. We're continuing to give all the good information we can, seeing comments in here.
Yeah, thanks for the feedback. That's really helpful to us.
Yeah, thank you guys. We love seeing the feedback. John and I can think what information is great, but it only gets us so far, right?
So, Summer makes a good point. If anybody has topics that they want to, because we do this a couple of times a year. So if anybody has topics that they want to see us cover, please let us know.
Of course, John has the legal perspective and I have the HR. Okay, this is how it's connecting in my brain as I've talked to others of you and want to make sure that it makes sense and that we're really trying to make your jobs easier. So, all right, John, well, I think we've got it from here, and
thank you, Summer.
See you all again soon. Thank you all for joining. Have a great day.
Thanks, everybody. Bye-bye.
Bye.